Hello and welcome to Moneylife. This is Sucheta Dilal. This week, let's talk about something that is of extreme concern to all of us, which is justice delivery. If you ever filed a case, it is something that should concern you. Things have changed today. Justice is on camera. How is this openness testing judicial conduct and what is going on? I'm sure you have a lot of thoughts like I do. Here's what I put together. Now, all of you know that Indian courtrooms are a closed arena. Long suffering litigants, judges, lawyers, court officials are the only ones that have known what goes on inside, what goes on in a courtroom. In fact, sometimes it's not even easy to hear what the judge is saying when you're standing in the courtroom. And this has been the situation for decades. It's a slow game akin to the theater of the absurd. Hearings drag on for decades. There are civil cases that had gone on for 30 odd years. There's supposed to be a fast track for senior citizens. Nothing works. Cases don't come up for hearing at all, especially if they're considered non important. And justice is routinely denied to all those but the most powerful and the rich because they're able to jump the system. This pathetic state of affairs was really known only to insiders. The rest of them said, "We have full faith in the legal system." Only those who have a brush with the system know how it works. Now things are changing dramatically. Thousands of people are following important court proceedings, and I say important ones because only the important ones are really being covered real time through live streams, live reporting, and on social media by specialized legal publications. Then there are those which may not be considered important, but because they matter to someone, they are clipped and there are viral video clips. These happen with family court hearings, accidents, all kinds of things that are really of public importance. So essentially, the judiciary's once hallowed sanctum is now open to the public gaze. We are able to look at what is happening inside courts, from the district level to the Supreme Court, from family court hearings on marital disputes to constitutional bench debates to issues of religion and free speech and people being hurt all the time and going there and getting long hearings quickly and repeatedly. While this is happening, every word and gesture of judges and lawyers is now open to our scrutiny. The result is a new kind of public engagement with the judicial system, one that has brought about some understanding of how it works and a lot of impatience as well. People can now see what kind of cases seem to hog judicial time and what cases linger endlessly even though they're important, what kind of people get bail, those who don't even get a hearing, and how courtroom conduct often strays from what should be okay if you look at judicial decorum. Yeah, that was a surprise to all of us. What really happens, what people say inside a courtroom. This increased public awareness has been a gradual process since a landmark decision of 2018 in the Swapnil Tripathi versus Supreme Court of India case. This case held that live streaming was a fundamental right of access to justice under Article 21 of the Constitution. Since then, live streaming has been happening. There are people who have fought the good fight other than this case. There's Indira Jai Singh, there's Jamshed Mistry who've been at it. But it's been a bold step towards transparency, which has also brought new pressures on judges and lawyers, and about time too. So, cameras and social media now dissect every raised eyebrow. The judiciary's image is being reframed real time, and people have lost their awe. In addition, you have artificial intelligence because these are tools and along with data analytics, which researchers can quickly use to analyze patterns in orders, expose judicial biases, or if certain kinds of issues get preferential treatment by certain judges. Public expectation has risen, and patience with judicial inefficiency is beginning to wear thin, especially since cost of litigation has risen in tandem with the delays in getting a final verdict. So it's tariq pe tariq, and you pay for your lawyer's appearance on each tariq with no sign of justice. And this is something that our judges and of course our lawyers, the lawyers benefit, but our judges don't seem to want to understand at all. So it's a paradox. Transparency means less visibility, but less reverence. And this is something for the judicial system and every stakeholder in it to worry about. So, what happens is oral remarks, quips from the bench, something that they just say that shows their inner bias about Pakistan or whatever. If you followed cases, you would know. Heated exchanges between lawyers, all of which did not make it to the public domain, is now out there. Every joke, every reprimand clipped and going viral for millions of views. In March 2023, the Supreme Court itself accepted this and said in a warning that live telecast attaches a stricter standard of responsibility on judges. Yet, there's no sign of restraint as yet. Let me give you a few examples. In October 2025, there was a public interest litigation being heard against India Bulls Housing Finance, which is now called Samman Capital. Senior advocate Harish Salve labeled the petitioner, which is an NGO called Citizens Whistleblower Forum, a blackmailer, repeatedly. This sentiment was also echoed by another very senior counsel. The person on the other side for CWBF, the Citizens Forum, was senior counsel Prashant Bhushan, who's highly reputed. He hit back hard. But consider how damaging this is. What is the Citizen Whistleblower Forum? It is not a fringe outfit. It was founded by very well regarded Delhi High Court Chief Justice A.P. Shah, former Central Information Commissioner Wajahat Habibullah, very respected bureaucrats turned activist Aruna Roy and E.S. Sarma, the late Admiral Ramdas, and Prashant Bhushan himself. This organization was set up precisely because the government has refused to operationalize the Whistleblower Protection Act for many, many years. When a forum of this level of credibility is branded as a blackmailer in no less than the Supreme Court, it sends a chilling message to citizen activists across India. Because many of us who do not have this reputation want to take up issues and think about what we would be called when you go to court. So, where we want people to fight back against wrongdoing, this has such a chilling impact. Something similar occurred in another case. This was a PIL which was seeking a detailed probe into Vedanta Limited and its group entities. Now, those of you who follow Moneylife know that there is a foreign short seller called Viceroy Research, which has put out a series of extremely detailed, backed up reports regarding Vedanta and its many affiliates, sister companies, listed ones. Now, Solicitor General Tushar Mehta alleged that this petition was motivated and appeared orchestrated by the foreign short seller. The PIL was later withdrawn. But it is striking that a top government law officer chose to defend a private conglomerate alleging motives on the part of the petitioner. We have written about it. It's written by bar and bench, but it doesn't end there. This petition was withdrawn. But remember that Viceroy has a series of reports and no Indian regulator, not the Ministry of Corporate Affairs, not SEBI, not RBI, has shown any sign that they're taking note of this or are even investigating it. It is of importance. These are listed companies. Vedanta itself has not given any detailed point-by-point rebuttal. All it has done is similar as what was said in court: dismiss Viceroy and say it's motivated, you're a short seller. Is this good enough? Why do we not have the right to get regulators? And remember, this is not the first time people have said, are regulators regulating and investigating, and are they doing it in time? But before we come to that, let me talk about another case. This happened in the Delhi High Court. It was a spectacle involving Mahesh Jithmalani, top lawyer and Rajya Sabha member, and another very well-known lawyer, Rajiv Nair. These two were caught on camera shouting each other down over a case that involves a 30,000 crore estate of the late industrialist Sanjay Kapoor. Why is Sanjay Kapoor so well known? Not only because he's the chairman of the listed company Sona BLW Precision Forgings, which is Sona Comstar, but he was once married to the movie star Karishma Kapoor, and her children are part of this fight over his estate. What happens? Shouting matches and no decorum. So I checked with several people. Not everyone wanted to go public, but senior counsel Dushyant Dave, very well known for being outspoken about The State of the Judiciary, notes that debate in the Supreme Court has degenerated over the years. In fact, he says lawyers representing powerful corporates and government interests routinely disrespect and sometimes run down their opponents. What is worse, he says, and this should worry us, is that judges often lack the courage to stop such behavior. They can do it. I mean, this is news to me. The public can see this for themselves now. We have experienced it ourselves. We are, called intemperate. We are called, liars, and nothing happens. All in the name of presenting the other side with no guardrails on what can be said and who can be labeled a blackmailer or worse. The most famous of these, as you know, is the Adani-Hindenburg saga. It is a case study in judicial optics. It attracted global scrutiny of India's markets, courts, regulators. When, when Hindenburg research, another short seller, triggered a big sell-off in Adani shares because it said that this was being massively, this group and its shares were being massively rigged up. This happened in 2023, January. Stock prices of all group companies fell, and there were several cases in the Supreme Court asking that the Securities and Exchange Board of India go and investigate this quickly and properly. And the suggestion was SEBI was not doing its job. When it went to the Supreme Court, instead of directing SEBI to complete its probe within a deadline, the Supreme Court did something which I consider very controversial. It constituted an expert committee who don't know what the regulator should do necessarily, barring maybe one or two members. It had former judges, bankers, tech luminaries who really know nothing about what should be happening in terms of market manipulation, essentially asking them to sit in judgment of SEBI and say, was SEBI doing its job or not? SEBI went and presented, other controversies came out, everything was finally bedded with SEBI giving a clean sheet to Adani by 2025. Why did all the share prices of this group shoot up more than any others? That question is no longer in the public domain because it's a clean sheet from the regulator. This is how it works. But this episode has continued to raise questions about process and accountability and whether the Supreme Court action actually harmed credibility more than it helped. Personally, I think it was harmful. We've written a lot about this. Those of you who want to see it, our articles are on Moneylife. Now, we're coming to PILs, public sentiment, and judicial frustration. This is not a one-way street. While I am making a case for people who file PILs and the chilling impact it has, there are also any number of frivolous PILs which find their way to court and sometimes even get time to be heard, especially the ones which are supposed to hurt some section or the other. This is essentially a business column, so I'm going to stick more to the business issues rather than religion and politics, but all of you know that that happens. And judges are getting tired of it. They are calling it an abuse of PILs. In fact, Justice B.V. Nagaratna, highly regarded, in March 2025, delivered a scathing critique saying many PILs have become paisa interest litigation, publicity interest litigation, or private interest litigation. I completely agree. It's a fact. And courts are responding to this as well. Courts have imposed heavy fines on frivolous litigation. There are any number of cases, but one example was of 2023 when the Supreme Court imposed a 5 lakh fine on a petitioner who claimed that the oath taken by the Bombay High Court Chief Justice was defective, fortunately thrown out. This frustration, if you ask me, is justified, but then courts are equally guilty of allowing all kinds of rubbish to come up before them and spend a lot of time hearing it. If they sent a signal, these would not come up. Many of these do not get fined or slapped with a penalty for frivolous litigation. Yet, when judges vent their irritation or question motives without due care, it risks delegitimizing genuine public interest activism. And the guardrails and the protection can only come from the judiciary, especially in an era where access to justice is already limited. This is another issue. Recusals. It's a new thing. If courts are exhibiting impatience over persons filing PILs, people are growing frustrated at corruption in the judiciary. You have examples of it coming out, and all kinds of issues. There's corruption, delays, and connections which, as I said, are manifest in the form of recusals. Now, in theory, recusals are a good thing because they protect impartiality. But when there's a rash of recusals and multiple judges are recusing themselves from hearing a particular case on personal grounds, you wonder what's going on. Is there a reluctance to deal with sensitive cases involving powerful corporations, influential citizens, and whistleblowers? Take the example of Indian Forest Service officer Sanjeev Chaturvedi. His public interest litigation on corruption is just being delayed because a dozen judges have recused themselves over the years. Now, recusals are certainly better than conflicted hearings, but they give the impression that some cases are too inconvenient to touch. In an ecosystem that's already burdened by chronic delays and pendency, such evasions compound the perception that justice bends to power. In fact, the National Judicial Data Grid says that as many as 5 crore cases, 50 million, are pending in courts. And innumerable cases, especially civil disputes, which are considered unimportant, drag on for decades. People have started litigating in the 50s and 60s, they're now in their 80s and spending money on tariq pe tariq. The judiciary's long standing aura of deference is eroding. People are not liking it. It is being replaced by a demand for accountability and performance. People are no longer willing to accept opacity in the name of sanctity. Lawyers and judges are now both public figures, both far better known to the people, and they are subject to the same unforgiving scrutiny as politicians, bureaucrats, and us journalists. So, courts around the world are grappling with this issue. It's not peculiar to India. Transparency is reshaping judicial authority everywhere. Stakes are higher over here because we have fewer judges, fewer courts, too many people, and the costs are too high. That really means that the system has to take note. The genie of transparency cannot be put back into the judicial bottle. It means that the bar of public conduct has to rise for lawyers and judges and the system as a whole. You have to complete cases in a time bound manner at lower costs. If courts fail to do it, they risk irrelevance or worse, even uncontrolled public anger, which can have severe consequences. For a nation that still sees the judiciary as the last line of defense, and yes, there are any number of cases that we are extremely grateful for, this would be a very big loss to bear. If you agree, please share this because we want the judiciary to wake up. We want a judicial system that works. This is not a critique. This is a plea for change because India needs that change. If you agree, please subscribe and do share.